Copyright in these lectures is either owned by the ANU or a third party who has licensed the ANU to use it. Students may use the recording for personal study only. No lecture may be communicated online, copied or shared without the prior permission of the ANU.
Question for you at the moment in terms of your study is to go onto the course homepage to week 12 where I've uploaded the 2018 and 2017 exam papers. And if you have any time at all in the next week, the best thing you can do is to write the practice answers, because that'll give you a really good indication of how you're going in the course. Hopefully give you a lot of confidence, or it might freak you out. But either way, it'll be a useful process. If you're super busy and you don't have time to do that, even if you go through the exam papers and see if you can identify the legal issue, that is still a very worthwhile use of your time. Okay? It's the students who can't even identify the legal issue that are really in big trouble in the exam. But most of you, I think, will be able to identify the legal issue, and that will give you a bit of confidence that when you read a problem question, you know how to start. And then, of course, if you have time before next week, try and do the full answer. I have put the week 12 slides up, which has a bit of a general overview about the exam and also answers some questions commonly asked by students. I'll be updating those slides in the next few days just to put some more problem questions from the papers onto the slides. So the content will change slightly between now and next Friday. Your assignment marks will be returned next week. Not sure when, definitely by Friday next week. The tutors are working hard to finalise their marking, and then I'll start moderating, and then the marks will be released. There'll also be an answer guide uploaded to Wattle. If there's time in the revision lecture next week, I might also go through the answer guide in the lecture. Just because there's not very much time between the last lecture and the exam, I think it's only a week. Okay. Yeah, there will be some consultation times offered. Is our exam on Friday the 2nd, is that the first exam that you have? Yeah, okay. So in terms of tutors offering consultation times, it doesn't matter too much which days it is next week, it sounds like. So there'll be a range of times for you to choose from. Of course, you can go to any consultation time. Okay, so let's move on to the subject matter of today, which is intellectual property, which is chapter 21 of your textbook. Right. So the term intellectual property is the name that we give to the creations of authors and inventors. And there's 4 different pieces of legislation that govern intellectual property rights. There are a few other pieces of legislation that govern intellectual property rights, but for as far as what you're learning today, it's just going to be those 4 pieces of legislation. Excuse me. The Copyright Act, the Designs Act, the Patents Act, and the Trademarks Act. Oh, you can't see it. I'm so sorry. I think it has to warm up. Right, I don't think you missed much on the previous slide. Thank you for letting me know. When I started law school, they had overhead projectors and endless plastic clear sheets that went on to project, which was tedious as a student because you never knew where the lecturer was up to, and they were handwritten as well. Anyway, all right, so those are your 4 pieces of legislation. Okay, so we're going to start with copyright. One of the things, I guess, tasks for you in an exam scenario is once you've figured out that there's intellectual property rights involved, you then need to work out which piece of legislation applies to the circumstances. Okay? And often, but not always, there might also be contract law issues potentially, and in the relation to trademarks, there might also be Australian Consumer Law Section 18 issues arising. But yes, the first task for you is to work out which area of law applies, and the tutorial question for next week, that's the task, is you working out in relation to each component of IP which legislation applies. So let's look at copyright. Excuse me. So to have copyright in something means that you have the right to reproduce or copy something, and copyright law is about preventing other people who do not hold copyright from copying the material that you own without your permission, or without the owner's permission. Copyright owners have both moral and economic rights, and these rights are listed on page, or in section 31(1) of the textbook, which I'll extract for you in a moment. And the entire thing doesn't have to be copied in order for there to be a contravention. So in the case of the textbook, the whole textbook doesn't need to be photocopied or digitally stored before you have a contravention. It has to be a substantial part. Okay. And EMI songs illustrates this principle of what does it mean for a substantial part to have been copied. So this is on page 639 of the textbook. Those of you here who grew up in Australia might know the song Kookaburra Sits in the Old Gum Tree. It's a song that children learn at school. And those of you who know music will know what bars mean. But the song itself only has 4 bars of music. It's a very simple tune. And 2 of those bars were reproduced in a flute riff in another classic Australian song that came much later called Down Under by Men at Work. Now, the owners of the Kookaburra music, the actual author of the music had died. I think she left it to the Girl Scouts, sued the later work, Down Under, because they alleged that the later work, the Down Under song, had taken music from the Kookaburra song. And I'll just give you the court's conclusion. So the court said, here, the copyright work was clearly the source of much of the flute riff, and the copied features were a substantial part of it. Consequently, the reproduction of those parts of Kookaburra in Down Under was an infringement of Larrikin Music's copyright, and the defendants were ordered to pay 5% of oil royalties from 2002, which actually wasn't that much. And you can watch the YouTube videos later if you want to. I'm not sure that I'll have time for you today, but it just shows you the original song, the bit that was taken from it and put in the new song. And there's actually quite a few copyright cases that relate to use of music from other music. So there's a Led Zeppelin case there as well. And I want to move on to the Dickens case. So let me just jump ahead, sorry. So where is 31(1)? Okay, I'm just going one ahead from slide 7 to slide 8, just to give you what the section 31 provides you can do, which is discussed on page 638 of the textbook. So if you have copyright in something, the Copyright Act says that you can do the things that are in section 31, and if someone else who's not a copyright owner does those things, they've infringed your copyright. Okay, so section 31 provides the right to reproduce, publish, perform in public, communicate to the public, make an adaptation of, for example, adapting a book into a movie, make a sound recording of, or enter into a commercial rental agreement or copy of works of art, literature, music, films, broadcasts and computer programs. So we're just going to go back a slide to further look at 31. So the courts have said that, well, the legislation as well, that having an exclusive right to do those things that I just read out to you means that you should be able to have the right to prevent other people from doing it. And section 196(1) provides that copyright is personal property. And this case I'm about to talk to you about illustrates the point that there's two different types of property involved. For example, in a work, so in this case there was an unpublished manuscript. Charles Dickens, who's a famous English author, had an unpublished manuscript that he had written, and he left the manuscript to, he left all his papers to his sister-in-law, of which the manuscript was part of that. But he left his copyright, or all his other assets, to his children. So the sister-in-law wanted to sell the manuscript to a publisher. And the court ordered, this was before the Copyright Act, but this is what the common law position was, the court ordered that there were two different proprietary interests in that one document. There was the property right that the sister had, which was to the document, the physical document, but the intellectual property, the copyright, was a different, separate property interest that had been left to his children. Therefore, even though the sister-in-law had physical custody of the manuscript, she didn't have the right to sell the manuscript to another party for reproduction and publication. Okay, so there's two different rights, which I think probably is fairly logical for you given that you had the lecture last week. Whoa, was that my phone? Sorry. Okay, so now another very important point about copyright law that perhaps isn't necessarily intuitive for you is that copyright doesn't protect ideas or information. What it protects is the expression of those ideas or information. You can't just have an idea, you need to express that idea in a document or in some other physical form, or digital form even, but it's not just an idea. So let's look at the Donoghue and Allied Newspapers case. Oh, excuse me. So, Donoghue and Allied Stevensons. In 1931, a jockey, do you know what a jockey is? Jockey is usually quite a petite, compact person who rides a horse for horse racing. Okay, so a jockey gave interviews to the journalist about his racing career, and it was published in the News of the World. 5 years later, the journalist wanted to publish the articles in a different newspaper, and he got permission from the News of the World to publish the articles. He didn't get permission from the jockey, and the jockey brought an action for breach of copyright, and the jockey was unsuccessful. And this is because, in this case is on page 641, even though it was the jockey's life story, even though the jockey was quoted in the article, the jockey had not actually formulated or had a formulated expression of the idea. All the jockey had was his story that he told the journalist verbally. Okay? So the jockey did not have copyright in that article. Okay? You can see why the jockey would be a bit indignant. It's his life story, but he's got no ownership rights over it. Okay? Now, just another point, but we'll return to this later in the lecture. The reason why the journalist had to get permission from News of the World is because News of the World was his employer, and employers have ownership over works that their employees produce in the course of their employment. Okay. The other point to make in relation to Donoghue is that you could have two people who have the same idea or similar idea and both produce their own work independently, and there would be no copyright breach. Okay, so for a lot of the music cases where one person is alleging that someone else stole part of their music for their song, they have to show that there was an infringement of the copyright, not just that two independent parties both happened to come up with the same or similar tune or the same or similar idea for a novel. Okay. So, how does copyright protection arise? There's two, if you're considering whether the Copyright Act applies, you would need to consider which category of protection the item that you're looking at falls under. So the first category is original literary, dramatic, musical or artistic works. And the second category is subject matter other than work. I'll talk about these in more detail shortly. So once something protected comes into existence, copyright arises automatically. Now that's a pretty special thing, and the other three pieces of legislation that I'm going to talk about today, there's no automatic protections under that legislation. You need to register it for both trademarks, designs and patents. But copyright arises automatically just because the work's been created. You don't have to put copyright on anything that you make in order for you to have the copyright protections. Of course, if you want to, and so most textbooks will say copyright at the beginning, and that's really just telling the rest of the world that we are asserting our rights as copyright holders. Please don't copy our work. But you don't have to put that label on it in order to have the protections under the Copyright Act. Now, you'll note that I said it has to be original, and then it also has to be literary, dramatic, musical or artistic. So that's sort of two sub-criteria within that one, and I'll give you some cases to illustrate that for you. So in a problem question, you'd be asking, is it original? Has it already been created by someone else earlier? And then, is it literary, dramatic, musical or artistic? You might also, if it's an unpublished work, so if it's someone's novel that they've written and just left on their computer desktop, you need to ask whether the author was a qualified person or whether the work was first published in Australia. That's discussed in section 32(4). I think it's enough for you in an exam just to note those further qualifications for unpublished works. You don't need any more detail than what's on the slide. Now, what does it mean that a work must be original? The 2018 exam has a question where originality was relevant. These two cases in particular, actually it might be even for tutorial questions next week, you'll get to use those two cases. If you want to give yourself a head start on preparations, you might want to mark this slide. So the work could still be derivative. It could look like it's not particularly original, like it looks like it's still inspired by something else that's been around forever, but it must originate from a human author, one or more, not just a computer program, and it has to be the result of the author's skill and intellectual effort. Even if you think reading the work that the author didn't have much skill or much intellectual effort, we're not sort of assessing whether the book would win a prize. You're more just assessing, is there a human author and have they used their skill or effort to create this, this document or this work. The courts have said that compilations of existing information can be original. I think it's 643 of the textbook. Yeah, the originality is discussed on 642 of the textbook, paragraph 21.10. Desktop marketing systems and ICE TV are two of the most important cases on this point. Desktop marketing systems relates to CD-ROMs. Do you remember what they are? Yep, CDs. So Desktop Marketing produced and sold 3 CD-ROM software products that use data taken from Telstra's telephone directories, which I guess is kind of like information taken from what we'd now consider the white pages or the yellow pages that Telstra published. And Telstra sued for breach of copyright. Telstra argued, you've made these products based on our material, our documents that have addresses and phone numbers and names. And Desktop argued that, and this is a quote, a mere industrious collection of facts did not satisfy the Copyright Act's requirement that the work be original. So the court had to consider were Telstra's directories original works. And the court found that compilations of existing information can be original, but there's a test, and the test is whether the work involved a form of expression of the information that originated from the author and was not copied from elsewhere. The court said there wasn't enough to establish originality. Now, there was another similar case, Telstra and Phone Directories Company, where the court found that telephone directories were not original literary works because they were produced by an automated process with no direct human input. So if you're copying something that's not an original literary work, there's no breach of copyright. Okay, so I get the rule that or the test that you're really going to be applying in an exam situation is you're going to be asking yourself, is there a human involved in the process, or is it an automated process that's done by a computer program? If it's that second category, it's not going to meet the standard of originality. Now, ICE TV is a slightly different scenario. I feel like both these cases are quite dated because I don't know that. Well, there may be some people who still watch TV and use TV guides, but ICE TV was back when, well, it wasn't that long ago, but people used TV guides. So ICE TV was getting the information about what shows were on at what times with the different channels and putting them together online in a bit of a different format. So ICE TV provided an internet-based electronic television program guide which it put together from the weekly programming schedules that the different broadcasters produced. And these schedules had the starting times, the title of the programs and some other information, such as the rating and whether it was live or a repeat. But ICE TV in its online program only had the time and the title, and it had a different format. It was a slightly different type of table. And the High Court held in that case there was no copyright infringement because ICE TV Guide was compiled through the exercise of its own skill, judgment, labour and effort, therefore it was an original literary work. Okay, so in order for a work to be original, it doesn't matter that the contents exist in a different form somewhere else. Okay, and you'll get to look at that again in the tutorial question, the last or the second last tutorial question next week. Has anyone got any questions about that? Okay, so what is an artistic work? This is described in section 10. Okay, so an artistic work is a painting, sculpture, drawing, engraving or photograph, and there's an important qualification there for you, whether it is of artistic quality or not. And a drawing, there's a further definition of a drawing there for you. It could also be a building or a model of building or a work of artistic craftsmanship. Okay, what does that will be? I think for you in an exam, it will be pretty obvious from the words that I use in the problem question, if there is a question on this topic, whether something is an artistic work or not. Okay, you really just need to go through the checklist there and work out whether I'm referring to a sculpture or a drawing or something, and then apply section 10. If you think something might be an artistic work but it doesn't meet this definition, you could also consider whether it was a work of artistic craftsmanship. And this has a fairly strict test. The Cuisenaire and Reed case illustrates this for you. I don't know if, I think I might have used it at one primary school. I don't know if anyone else used it when they were learning maths, but some primary school students learn not to count, but to do mathematics, adding and addition, I guess, addition and subtraction, through using little wooden squares or rods. And a single square is 1 and a rod of 10 is 10, and it goes on. They mean different numbers. It's used in schools. Somebody was copying the rods, and so they brought an action for breach of copyright under the artistic craftsmanship clause. And the court had to consider, could the Cuisenaire system, which is coloured rods used to teach arithmetic, constitute an artistic work? And the court said no. The creator of the rods created them for children to learn maths. They did not create them to appeal to the aesthetic tastes of those who observed it. Okay, so if it has a very functional role, it's not going to be covered under artistic craftsmanship. Okay. It's discussed in more detail on page 646. Other works that have been held not to be works of artistic craftsmanship include cobbler, somebody who makes shoes, a dental mechanic, and a wheelwright. However, they said the maker of this is the court in the George Henshaw case, said the maker of hand-painted tiles that would then functionally be going in a bathroom or a kitchen could be a work of artistic craftsmanship because they're created to appeal to the aesthetic tastes. Okay. And I think I've already discussed literary works. Dramatic works, it's fairly obvious again, maybe a script for a movie, but not the movie itself or the script for a play. Musical works, a bit more obvious. Literary works is defined in the Aristocrat leisure case as something that it's intended to afford either information, instruction or pleasure in the form of visual enjoyment. That's the Aristocrat leisure case on page 644. Information can still be a literary work, even if it's not something you would ordinarily buy at a bookstore. So a telephone category, a telephone directory would be a literary work. Other examples include specifications for poker machine games, coupons, and so on. Okay. Now, that's the first category of intellectual property. The other category, so original literary, artistic or musical works. I now want to turn to the second category, which is subject matter other than works. So if there's subject matter in your problem question that doesn't meet the first criteria, you then need to consider whether it would meet the second criteria. But this is really just deals with sound recordings and films, including DVDs, pre-recorded television programs, videos, radio and television broadcasts, and so on. There's different rights that attach to each of those different types of works, and they're pretty logical, I think, and they overlap somewhat. And a contravention of what they're detailed for you on page 647, sections 85 through to 88 of the Copyright Act. Keep in mind, if you do have an exam question where, for example, you're looking at subject matter other than works, there might be multiple contraventions from the single act. So if, for example, you're showing a film say I was putting a film on straight after the lecture and I was charging people to come in and I didn't have permission to put it on, I could be contravening the Act, Section 86, in relation to showing a film that I didn't have a right to do. But also, if there was a song being played in that film, I might also be contravening the provisions against music without permission, and so on. And that's what happened in the Federation of Australian Commercial Television Stations 1998 case. Okay. So, who is protected? The person protected by copyright is the person who owns it, which I think is fairly obvious, but sometimes you might need to consider who can own things. You need to have created the work or bought the rights from someone else in order to have the copyright protections. In the Bullen Bullen case, the artist used stories from the Gunul Bingal people to create an artistic work, a painting, and then that painting was reproduced and it wasn't authorised, that reproduction. The only person whose rights had been infringed was the artist who created the paintings, not the entire people group who owned the stories that were depicted in the paintings. Okay, so the creator owns the rights unless the creator has sold those rights to another party. The other exception to that general rule about ownership is that journalists and photographers do not own copyright if they were paid to produce the work by their employer. Specifically, journalists and photographers are mentioned there in 35 subsection 4 and 5. And also people who are producing the literary or artistic work in the course of their employment or training. They also don't have ownership for that item. If you're interested in the Albert Namatjira case, you can have a look, follow those links later. I don't think I will go through them today with you. Okay, so how long does copyright last? There's going to be new rules from the 1st of January 2019. Those rules aren't the law yet, so I'm teaching you the law as it is right now. But yes, just be aware that the rules about how long a copyright lasts for will be changing from 1st of January 2019, and I've put a post on Wattle about that, and the links are there for you. But for exam purposes, you're only going to be tested on the law as it currently is, which is what's on the slides today. So how long the copyright lasts for depends in part upon what type of work it is. So if it's a literary, dramatic or musical work, copyright continues for the life of the author or the creator, and then once they've died, 70 years after the date of their death. Okay, so copyright, if you've been a successful author, can be quite a valuable asset to leave to someone in your will. That's if the work's published in their lifetime. If the work isn't published till after their death, then it's 70 years after first publication. And we've got similar provisions there for photographs and engravings, except for photographs and engravings, sound recordings and film, there's not that additional lifetime period. So it's 70 years from the date of publication. TV and sound broadcast is 50 years from the year that it was first broadcast. 25 years for published editions of work, which might be works that have already been published previously. And then I've said thereafter the work is in the public domain. What does it mean if copyright has run out and something is in the public domain? If the protections aren't there anymore, then anyone can go and publish the work. Okay, so if anyone in this room wanted to publish the works of Charles Dickens, for example, you could do it. You wouldn't have to pay Charles Dickens' estate anything. if you want to publish Great Expectations and Hard Times and everything else. Okay, so yes, copyright is really good, but once it's run out, there's no value left in the asset really. Now, I've put a note there that the Productivity Commission, which is an independent government agency that reviews all sorts of different things, they did a report on copyright, and they recommended in that a reduction of the 70-year copyright term to a term of between 15 and 25 years. That recommendation hasn't been fully implemented by the bill, but it was the recommendations in that report that have led to the changes that will come into place on the 1st of January next year. Now, in an exam, if you've worked out that yes, there is a work that is protected by copyright, you would then usually need to consider what happens next if it's been infringed. Okay? So Section 36, subsection 1, basically says that if anyone does the things listed in Section 31 without permission, then they have infringed their copyright. Okay, so Section 31(1) set out all the things that a copyright owner can do with their work. If someone else does that without licence, then they have infringed it. Section 38 makes the sale, hire or exhibition of pirated copies or infringing copies an infringement of the Copyright Act. So even if you didn't reproduce the work, if you're then selling the work in your stall, you will have infringed or breached Section 38. Okay. There was a 1997 case where Telstra was held to have infringed copyright when it supplied music to callers when they got called up for hold music. I meant to mention that case earlier in relation to... Okay, don't worry about it. I won't assess you on that particular case. Okay, let's keep going for infringement. Now, authorising or enabling someone else to infringe copyright is also a breach of copyright. Now, I doubt, are there still photocopiers in the libraries at ANU? I don't know, does anyone use them? No? When I was doing my undergrad, you used to have to line up. There'd be a queue of people for the photocopier, and you'd have all your journal articles or cases that you needed, and you'd photocopy them. Okay, I wasn't at uni in the 70s, but this is what was happening in the 70s. People were, I think students were photocopying one of Frank Morehouse's novels because they didn't want to buy it. And I think Frank Morehouse, who's a famous Australian author, decided there wasn't much good in suing impoverished students for damages. Perhaps he would sue the university. So he brought a legal action against the University of New South Wales that said, by providing the book in the library and also having a photocopier, you are authorising or enabling students to breach or infringe my copyright. Because of the way you've set everything up, students are able to copy my book, which is infringing my copyright. So following that case, Parliament then amended the legislation that gave libraries a defence. So if you are, I think there might still be photocopiers in the library. Next time you're in there, is Chifley the one that you guys go to most? If you ever can't find a desk at Chifley, there's usually one at Menzies. That's just a hot tip for you. Anyway, next time you're at Chifley Library, if you can find a photocopier, just get up close because there'll be an A4 sheet that tells you what the copyright laws are and tells you what you can photocopy and how much and so on. And the reason the libraries have put that up there is because of the defence in Section 39 capital A, which says it is a defence that if you put a warning notice next to the photocopier saying don't infringe the Copyright Act, don't copy more than 10% of a book, for example, then you will not be considered to be authorising the infringement of copyright. Okay? Whether or not the students follow that is another issue, but simply putting the sign up is a defence. There's an interesting 2018 copyright infringement case on that link if you'd like to read it regarding the Love Is in the Air song. I'm just going to leave it there and keep going for Roadshow Entertainment. Okay. Now, there's a series of cases, Roadshow Films and also the Dallas Buyers Club case, where copyright owners have been were getting extremely frustrated, and perhaps frustrated might not even be the right word, but they felt like they were losing a lot of money because Australians kept downloading movies instead of going to the movie theatre or buying it on DVD. And a lot of these cases are a bit older. So this was a 2012 case. The Dallas Buyers Club is a few years after that. But it's only very recently in Australia that you could even access streaming services like Netflix, or that you could even access Game of Thrones. Apparently Australia has the biggest illegal Game of Thrones download in the world. But there was a period where Australians couldn't even purchase it legally. Like if you wanted to watch Game of Thrones at the same time people in the US were, you couldn't even purchase it legally. So there was a lot of downloads, and it wasn't, I don't think, just people who didn't want to pay the fee. Oftentimes there wasn't even a legal way to access that film because of rules about when things were released in Australia. So Roadshow Films Proprietary Limited had a good idea, they thought. They decided they would get iiNet, they would take iiNet, an internet service provider, to court because their clients were using their service provider to download these films. Okay, so this is the first attempt, 21, and it's at 21.23. So iiNet was an Australian internet service provider, and the appellants, so it wasn't just Roadshow Films, it was a whole group, were 34 Australian and US companies that owned or had exclusive licenses to copyright films and television programs. They started to send notices to iiNet about its customers' copyright infringements. And what they wanted iiNet to do was to suspend or terminate these customers' access to the internet. And iiNet refused to do that. And so then the appellants, Roadshow Films and Co., the ORS in the heading there, see how it says Roadshow Films Proprietary Limited, an ORS? It's a legal way of writing others in a case name because it's too long a case name to write all 34 names. So they brought proceedings in the Federal Court of Australia saying that iiNet's customers used the internet service provider to infringe copyright by making films and television programs available online through BitTorrent. And therefore, this is the clincher in terms of infringement, they said iiNet was authorising the copyright infringement. That was their argument. Now, you've got the lower court there, and then, so first instance, the court found that iiNet did not authorise its customers' copyright infringement. Then there was appeal to the federal court, full federal court, which was unsuccessful. Then it went to the High Court. And this is what the High Court held. So it went all the way to the top. There were 3 judges sitting, Chief Justice French, Justice Crennan and Justice Kiefel. iiNet had no direct technical power over its users' infringements. It could only do it indirectly by terminating the account based on the contractual relationship between the parties. But then the judge said, well, even if iiNet had terminated or suspended the accounts, the customers could just sign up to another internet service provider and continue to download films or make them available to others. Therefore, iiNet's failure to act upon the notices about the user's infringement did not demonstrate indifference, but rather an unwillingness to act just on those notices without further investigation. Therefore, iiNet had not authorised the infringing. And Gummow and Hain reached a similar view. Again, they were saying iiNet could not control its subscribers' use of BitTorrent software, and iiNet couldn't take down the films that were available online. iiNet wasn't hosting the web pages that were making the movies available. And the users could take their business to another internet company. So they were unsuccessful in the roadshow cases. So then they tried again. I don't know why they chose iiNet and not any other internet service provider. They tried again in 2015. Oops, excuse me. Has anyone seen the film Dallas Buyers Club? I've not seen it. Apparently a lot of Australians have downloaded it and watched it illegally. So copyright owners of this particular film, this time they thought, well, what we'll try and get from iiNet, we're not going to ask iiNet to cancel the internet plans that these subscribers have. What we're going to ask is them to give us the names and the addresses of these subscribers so we can then send them notices. And the court said, yes, but, okay. So the court said, okay, iiNet will hand over the names, but you need to let us look at the letter, us being the court. You need to let us review the letter that you're going to send to the subscribers. And also, because we're not sure if you're going to do the right thing with that letter, because the companies, most of them were based in the US, you also need to pay a bond. I think it was $400,000. And if you don't comply, then we keep the money. And they never got back on time. The court set a due date for the letter to be sent to the court for review, and the Dallas Buyers Club licensees and copyright owners never sent the letter. What the court was worried about is that the companies would do what they had been doing in the US, which is sending people letters, very scary legal letters, asking for hundreds of thousands of dollars. Okay, basically speculative invoicing. And what the court said is, well, really, all you're entitled to is how much it would have cost to watch Dallas Buyers Club on iTunes, plus maybe some administrative costs. So maybe, I don't know how much it costs to watch Dallas Buyers Club on iTunes. $12? $15? Not much, not thousands, not hundreds of dollars. And so they never handed the letter over, and so the whole matter just fell away. Okay. I'll just quickly talk about Village Roadshow and then we'll have a break. There have been some amendments to the Copyright Act in 2015, so importantly Section 115 capital A, and this allows the Federal Court to grant copyright owners an injunction that gets internet services providers to take reasonable steps to disable access to particular websites that are hosting infringing material. And there's particular conditions that have to be met. There's a bill, and I put the post on Wattle last night, there was a bill that was introduced into the House of Representatives yesterday that further enhances these powers that were introduced in 2015. The bill isn't law yet, so I guess just be aware that the law is changing in that space, but again, the slides represent the law as it is today, not what it will look like in the next 6 to 12 months. Okay, well, let's take a 10-minute break. Just come back in 10 minutes. I've got 3 different clocks here. They all say different things. So just look at your clock and come back in 10 minutes, or on this screen here, come back at 5:03 on the computer screen. Hey, Kim, how you going? But in the US, some people have been charged for how many people have. Okay, let's keep going. I'll probably go over the next few slides fairly quickly in relation to parallel importation. But the Copyright Act does prohibit owners of overseas copyright from importing copies that would infringe Australian copyright. So the way copyright works is different parties will have different licensing rights. And just to protect what people have paid for, which is why actually Netflix in Australia, there's a lot of shows that you can't watch on Netflix in Australia, even though you could watch it on Netflix in the US, because the licensing is different. So when Netflix launched itself here, some of the shows had already been purchased by Foxtel, and so, yeah, that's just an explanation for you. Although there have been some modification to those laws. Another point in relation to literary, dramatic or musical works, permitting the use or performance of another's work is an infringement unless you were unaware or had no reasonable grounds to suspect or you didn't charge fees. So I guess if I showed a movie tonight to you instead of a lecture, ANU could argue that it was unaware that I was going to do that and therefore it wasn't permitting the performance, the use of the work. Okay. Now, of course, you should consider defences. So if you consider there has been a copyright infringement, you should still, in your exam answer, consider whether there's any defences to that infringement. The simplest defence is to say, the copyright owner told me I could do it. So if you had a license agreement or a consent from the copyright owner to do the thing that you did, then you'll be okay. You could argue that it was fair dealing for research or study. For example, in relation to the textbook, you could photocopy up to 10% or one chapter, and that would be a defence to infringing. If it's a copy of a work that's in a public place, or incidental inclusions or copyright work in a TV show that perhaps was in the background, or if you're making a recording to watch later, which was quite a big deal when the Copyright Act was passed. People used to time their video players to tape their favourite shows so they could watch it later. That is not an infringement under the Copyright Act. And remedies. You always need to consider what remedies are available. And some of these remedies will be familiar to you and some we haven't looked at for a while. So, the court can grant injunctions, and it can grant damages or an account of profits. I don't think we've talked about an account of profits since I talked to you about contract law, but say someone copies my novel and they sell it and make lots of money, that money, account of profits would be that the money would be paid to me as part of the court order. Okay, because your person who's experienced the copyright infringement might not always have suffered damage or loss. Okay, and so simply someone else making money off the infringement could could mean that the court would order an account of profits. The court could also order additional damages if it considered it appropriate. You could sue for conversion or detention. Don't worry too much about that one. There's also penal sanctions, and you can seek an Anton Pillar order from the court. And the court could also order the destruction of infringing copies. So if someone copied my novel and they could order that they be handed over to me or that they be burnt, for example. An Anton Pillar order is when the court grants an injunction where you can go and seize the material that is subject, that is the copyright infringement. If you suspect there's a warehouse full of copyright infringing material, but you're worried that the evidence will be destroyed, that the person who's infringed the copyright will burn the book so there's no evidence that the copyright was infringed, you might seek an Anton Pillar order, which will enable those books to be seized even before the court has determined whether the copyright infringement has occurred. Okay. Now, there's some additional rights held by copyright owners, and these are moral rights. And these rights rest with the creator of the work. And the creator of the work holds on to the moral rights even if they've sold the property rights in the copyright material. So if you're an author of a book and you've sold the book or the rights to reproduce the book to a publisher, you still retain the moral rights. Okay? So even if someone doesn't own the proprietary copyright in their work anymore, they will still have moral rights in the work. And there's 3 moral rights outlined in the Copyright Act. The right to attribution of authorship or performance, so the right to have your name on the book, for example. The right against false attribution or authorship, which is similar to the first one, and the right of integrity of authorship or performance. Okay. So the remedies for moral rights are a little different. Well, the provisions are different at least. Injunction damages, which you're familiar with. Declaration, so it might be a requirement to have something printed in the newspaper saying Bonnie Allen did write this particular book or we misused her name, and orders that any false attribution be removed or reversed. The court has fairly broad discretion in the context of deciding what remedy to grant for the infringement of moral rights. They can look at the particular circumstances of the case to determine what's appropriate. Okay, does anyone have any questions about copyright? I'm sure you have lots of questions about designs because I haven't lectured on it yet. Okay, I'm going to go through designs and patents in less detail than I go through copyright and trademark. Copyright and trademark there's a bit more content on that. Okay, so designs. This is the second piece of IP legislation. And you've got the Designs Act 2003 and also the Designs Regulations. You might remember from the beginning of the course, you have legislation but also subordinate legislation, such as regulations that are authorised by the Act. Regulations can be changed much more easily than the legislation. So Section 5 gives you the definition of the design as the overall appearance of the product resulting from one or more visual features of the product. And the Design Act was created in recognition that the look of particular products can make them more appealing to buyers. So the shape of the item or the colour or the scent and so on. Not the scent, sorry. The colour, the shape, or just what it looks like is part of what is commercially valuable about the product. And then there's also a definition of product. It's a thing that is manufactured or handmade, and it includes a component part of a complex product. if it is made separately from the product. And kits, so like an IKEA table, for example, that when assembled form a product. A visual feature is defined in 7.1 to include the shape, configuration, pattern and ornamentation of a product, and a visual feature may but need not serve a functional purpose. So the visual feature doesn't have to be useful, but it might be. And the legislation also provides that the feel of the product and the materials used in the product are not part of the visual features. Okay, and this picture I've taken from the Intellectual Property Australia website, and it's giving you an example. I think you can tell that second image is a box. So the picture's been put on the box. So the first example is a picture of some trees. This is not a design, but once it's put on the box, the packaging as a whole becomes a design that might be covered under the Designs Act. The design also has to be new or distinctive. It's distinctive, it meets the definition of new unless it's substantially similar. And what do you do? So unlike the Copyright Act, where merely creating the work attracts copyright protections, you need to do something extra in order to have the protections under the Design Act. So you need to make an application to register it. You need to provide some fairly obvious information like what the design is and what it looks like. And there's also an online database of designs. So if you Google Australian Designs Data Searching online database, it's on the IP Australia website, it used to be, anyway it will come up under Google. You can search for designs that have already been registered, and that would help you figure out how to make a design that wasn't already substantially similar to a design that was registered. You could decide whether to register it or to publish it. They both have advantages. There's more work involved in registering a design. There's much less work involved in simply publishing it. But publication still brings about some protections. It prevents other people from having the same design. Okay, there's someone who examines registered designs if requested. And what are your protections if you've registered? The owner of a registered design has exclusive use in dealing with the designs, and there's remedies if there's an infringement. So if you had a problem questioning you thought designs were relevant, you'd really just be considering whether the thing in the question looked like a design, met the definition of design, and you'd be really looking carefully in the facts to find out whether the person has already registered or published the design, because the rights that flow from that will only flow from that if the design has been registered or published. Okay? The mere existence in a fact scenario of a design that meets the definition in the Design Act doesn't mean anything. Okay. There is a spare parts exception, which is really mostly about cars. Spare parts can be made generic spare parts for cars without breaching the design rules. Now, another difference, do you remember how many years copyright could last for? 70? Yeah, depending on the type of work, it could be the life of the creator plus 70 or just 70. Whereas designs only last for 5 years after the filing date, and that can be renewed for a further 5 years. The maximum period of registered protection is 10 years, so it's not very much. And yeah, you need to put a calendar reminder in. So if you have registered it, you need to re-register it before another 5 years has passed. Now, there's a bit of overlap potentially between design rules and artistic works under the Copyright Act. Now, remembering that the protections under the Copyright Act are very generous compared to the protections under the Design Act. You know, obviously people would prefer it if their work could be classified as an artistic work, because then they're going to have, the protections will last for so much longer. However, Section 74 to 77 capital A of the Copyright Act addresses this. So those provisions prevent people taking the more favourable provisions under the Copyright Act for artistic works if the designs are being used to produce industrial products. Okay, so if it's not just an artistic work, if it's an artistic work that's being used to produce industrial products, then it will not have copyright protections. It would need to be registered under the Design Act to have any protections at all. Okay. So that's designs. I went through that fairly quickly. You'll have an opportunity to consider when the Designs Act might apply in the tutorial next week, the first question. I'm going to look at patents as well. Patents is about the protection of inventions. Patent law is very, very complicated and you will not master it today, but hopefully you'll be familiar enough with it that you'll be aware when an issue requiring that might come under the Patents Act has arisen. So, what is a patent? A patent is a monopoly granted by the Crown, giving inventors the exclusive right to exploit their inventions commercially for a specified period of time, the term of the patent. So patents are all about inventions, and all of these IP, all the IP legislation does essentially create a monopoly for a period of time. It's a collection of rights to exploit whatever's been created for a specified period of time and to bring action against others who try to exploit your exclusive right. So what can be patented? Any invention, so it has to be a new device, substance, method or process, has to have a manner of manufacture, has to be novel, it has to involve an inventive or innovative step, it has to be useful, and it must not have been secretly used before the priority date. So if you have something that you want to patent, you can't be using it and selling it before, for a long period of time before the priority date. Manner of manufacture. What does that mean? It's the mode or manner by which an inventor provides the new and useful effect that is the result of his or her invention. And all that is required is that the invention result in a vendable product. That is something that can be used in a practical economic step. There's a novelty requirement, so you can't patent something that's already been around forever. It can consist of taking a known invention and adapting it to a similar but different use. An invention will not involve an inventive step if it would be obvious to a person skilled in that particular field. So if professionals or tradespeople in that particular area are already engaged in that practice or using that particular type of tool, then that's not something that can be patented. It has to be inventive and new. And it has to involve the use of a person's inventive intellectual faculties. The test of usefulness isn't, is this something the world needs? Is this something everyone should buy? That is not the test of usefulness. The test of usefulness simply is, does it do what the inventor claims it does? Does it work? And to discourage people from, I guess, trying to stretch out the patent period longer, they can't have been concealing use of that product. So they can't have been selling it and using it for some time before they register the patent. So remembering again that the Patents Act is different to the Copyright Act but is similar to the Designs Act in that none of the rights and protections under the Patents Act arise unless you do something proactive. Okay, so in this case, you need to file a patent request with the Patent Office. And once you've done that, you have exclusive rights and use of dealing with the patent. If the patent is produced in conjunction with employment, then sometimes the person who who made the invention will have the rights or the ownership to that item, and sometimes the employer will have the rights or the ownership. So this particular slide involves, or this particular case involves, issues of contract law as well as patent law. It's on page 668 of the textbook. And the test really is whether the employee was employed to discover or develop that particular invention. Was it within the course of his or her employment, or was it outside the scope of their employment? If it's within the course of their employment, if it was part of what they were paid to do by their employer, then the employer will own the rights to that item, to the patent. If it's outside the course of their employment, or it's not what they were being paid to do, it wasn't part of their job duties, even if they did it potentially on work time, then they will be more likely to own the rights. So the court had to consider this very issue in the University of Western Australia and Gray case. Professor Gray was a professor of surgery at the University of Western Australia, and his employment contract required him to undertake, organise and stimulate research. He developed a number of inventions for the treatment of tumours in the liver, and the university claimed ownership in those inventions. The university argued that the inventions had been developed in the course and scope of Professor Gray's employment. Professor Gray disagreed and argued that he owned those inventions. So the court had to consider, they had to look at Professor Gray's contract and look at the invention, and they had to consider, did the contract between Professor Gray and the university give the university the right to his inventions? And so that's I guess the rule that you would have to apply to any future case, is looking at the contract and the actual job and then deciding whether the employer had ownership. And in this particular case, the court determined that the employer did not own the inventions. They said that as an academic, Professor Gray had the freedom to choose the subjects he researched, and while he certainly had a duty to research, he did not have a duty to invent. Consequently, his inventions were not made within the scope of his employment, the university had no rights to them, and he was entitled to exploit them for his own benefit. That is, he's entitled to make money from it. The court did note that if his contract had required him to produce inventions or to do research with a view to inventing something, then the inventions might belong to the university. So it really depends on the facts of the particular case. So infringements are important, but of course this infringement material is only going to be relevant if somebody actually has a patent. Okay, so if you've got an exam question where somebody has got this amazing invention, but they've not actually patented it, then they're not going to have the rights and remedies listed here. So, remedies include, and you should be familiar with injunction by now, damages, account of profits. Legal authority for that is section 122 of the Patents Act. And I've just got a note there for you. I'm not teaching you international patent law, it's super complicated, but there is an international convention for the protection of industrial property and patent cooperation treaty that many nation states have signed up to, that really are different countries trying to work together to cooperate to ensure that patents are protected. So if someone has a patent in Australia, then hopefully if they've registered it in the right way, there's a way for them to also have protections elsewhere. Okay, but yeah, it's a very, complicated area, there's dedicated patent lawyers who they spend their life just looking at patent law. So there's a lot more content to patents than just 10 slides. Okay, how are we going for time? I think we might keep going with trademarks. If we do get through all the lecture material today, that's fantastic. But if we don't, we'll finish next week. But if we do get through it all today, that just means there's more time next week to do more practice questions, which is good prep for your exam anyway. So let's move on to trademarks. And you might want to write on the top of your page, although I think I have it in the slides too, that if you're looking at trademarks often, you might also need to be looking at Section 18 of Australian Consumer Law. Okay, so what is a trademark? Section 17 gives you the definition. There's a tutorial question for next week on what could be a trademark, tutorial question 2, I think. So trademark is a sign used or intended to be used to distinguish goods or services dealt with or provided in the course of trade by a person from goods or services so dealt with or provided by another person. So it's a sign, and I'll give you the definition of a sign in a moment, that is used to distinguish what you're trying to sell from your competitor, so that the consumer knows which is your product and that it's not someone else's product. Okay? Now, sign, this is what's in the tutorial question for next week, is incredibly broad definition. So Section 6 says a sign could include the following or any combination of the following: a letter, word, name, signature, number, device, brand, heading, label, ticket, aspect of packaging, shape, colour, sound or scent. It's extremely broad. I feel like it should say a sign is like anything that distinguishes your product. But anyway, there's your definition for you in Section 6. I think scent is particularly cool. And in the tutorial question, I've just asked you to think about what some actual examples you can think of as trademarks that might fall under those different types. Now you'll notice, if we just go back to Section 17, I said a sign used or intended to be used. So it doesn't actually have to be used, but it needs to be intended to be used. And has to indicate a connection between the goods and the person who applies to mark the goods. And the reason they say intended to be used is you might not yet be ready to sell your product. You might be at the stage of your business where you're just getting all your paperwork in order. So you're intending to use it in the future. It's not going to stop you from registering the trademark. Now, there's 34 classes of goods and 11 classes of services in the trademarks regulations. I don't think they're extracted in the textbook. I might put them on Waddle if I think you need them, but there are many different categories of goods and services, and you can register your trademark under a particular category. Okay, now if you have an unregistered trademark, so you might have your own, I have quite a few friends who have small businesses making various things that they sell at markets, and I don't think any of them have registered it as a trademark, but they've still got an image and a logo, and it essentially looks like a trademark, but it's not a registered trademark. So you can still use an unregistered trademark. It's not an offence to have a sign that distinguishes your product from other people's that's not registered, but your legal remedies are much more limited. So if you haven't registered your trademark, you don't get any of the protections under the Trademarks Act. You might still be able to bring an action under Section 18 of Australian Consumer Law or sue in passing off. And I'll talk about that at the end of the lecture today or next week. So I guess you could just write a note for yourself that if the person in the problem question hasn't registered their trademark, they might still be able to get some relief under Section 18 of the Australian Consumer Law relating to misleading and deceptive conduct. or possibly the tort of passing off. Okay. Before a mark is registered, you can still identify it as your trademark by using the words TM. And that's really just a message to other people that you're using it as a trademark and they shouldn't use it. But again, it doesn't really provide any legal protections. But if you do register your trademark, there are some benefits. You have exclusive rights to the trademark and you can get remedies under the Act if someone else uses your trademark. Okay. So what do you need to do to register? You have to lodge an application with the Trademarks Office, and a trademark can be removed from the register if it's not being used. So if somebody has already registered a trademark that you would like and it hasn't been in use for 3 years, then you could apply for it to be removed under Section 92. Was that a question? No. Okay. Now, there's some circumstances where a trademark cannot be registered. If it's likely to, under Section 43, to deceive or cause confusion amongst other people, consumers looking to purchase the product, then it cannot be registered. And it also can't be registered if it's substantially identical with or deceptively similar to a trademark already registered by someone who's selling similar goods or closely related services. That's why that classification list is practically quite relevant, although I don't need you to know about that list for the exam purposes. But so if you were registering your trademark in the context of pet food, if it was similar in colour or design or logo or whatever to someone who's selling agricultural machinery, probably not going to be a problem, okay? Because it's a different class of goods. Okay. What time is it? 5:35. Okay. So the trademark has to distinguish the applicant's goods or services, Section 41. This is a case regarding colour. So a colour can be registered, and there's quite a few colour cases. So you've got Woolworths there, Woolworths Petrol, green, and then BP, British Petroleum Petrol, which has traditionally had yellow and green colours. BP's been around a lot longer selling petrol than Woolworths. And just to cut to the end, BP was unsuccessful in registering a particular shade of green. They wanted to register the green that was the same as the Woolworths green, and Woolworths objected. They said, this is too similar to our trademark, it's going to deceive people, they're going to get confused. You shouldn't allow the registration. And the court agreed and didn't allow the registration of the green. The technical reason for really was that BP had always used green in the context of green and yellow. It hadn't used that particular shade of green on its own. Therefore, it couldn't successfully argue that it had prior use and a history of being that particular green. Yes, it's strange to think of courts talking about colours in such detail. Okay, and bizarrely, Woolworths and BP, years after this case, were trying to merge. Woolworths was trying to sell their petrol stations to BP, perhaps on the view that consumers wouldn't be confused. Now, a trademark also has to be adapted to distinguish the owner's goods or services. So these cases are really perhaps what you would mention in conjunction with the relevant provisions on slide 54. So it has to distinguish the owner's goods and services. So in the Cantarella case, Cantarella owned trademarks of Oro and, my Italian's not very good, Cinque Sterle in respect of coffee products, and Medina wanted to cancel the trademarks. The issue was whether they were inherently adapted to distinguish the appellant's goods. And there's a picture there of the Vittoria coffee. The court confirmed, this is the High Court, so it's good law for you, that the test to be applied when assessing the inherent distinctiveness of foreign words under Australian trademark law is the same as it is for the English words. So the test is, an assessment of the ordinary signification of the words, having regard to persons who will purchase, consume or trade in the goods, and the historical context of Australia being an English-speaking nation. I might go through that case in a little bit more detail next week, but I'm still keen to keep going through the lecture today so you've got all the content while you're doing the practice exams. So what are the rights that you get if you have registered a trademark? You have an exclusive right to use the trademark, to authorise other people to use the trademark, and you have the right to remedies if someone else infringes your rights. So if someone else does the things that you have the right to do, so if they start using it. Now, how long does trademark last for? Again, this is not as good as the copyright law, but is a little better than the Design Act. So the registration of a trademark expires after 10 years, and it can be renewed, ongoing renewal, as many times as you like, each time for a period of 10 years. But remembering Section 92 provides that there can be removal for non-use. So if it's not, even if the 10 years aren't up, if it hasn't been used for 3 years, someone else can apply to remove it from the register. A registered trademark is infringed by a person who uses as a trademark a sign that is substantially identical with or deceptively similar to the plaintiff's trademark. So you recall a moment ago I said that if something's substantially similar to or substantially identical or deceptively similar, I don't care too much if you're applying this in an exam for you to work out which of those applies. You could just argue the test as a whole. But those two things could prevent a trademark being registered. But once a trademark is registered, if someone else has a trademark that is substantially identical or deceptively similar that they're using, then that would be a contravention of your rights as a trademark holder. And the remedies for infringement of a trademark include an injunction and damages or an account of profits. Remembering that damages is what you get if there's, well, what you would apply for if you've suffered loss. Account of profits is what you'd apply for as if the infringer has made money off using your trademark, off the infringement. Okay. Now, does anyone here have any UGG Australia boots? Branded UGG Australia? Are they still cool? You see them around sometimes. Apparently they're quite popular in the US. And before ANU moved to 12-week semesters instead of 13-week semesters, we used to watch the UGG boot documentary, which is about these cases. So do you know what an UGG boot is? I think I've got it on the slide there anyway. So it's like a sheep's wool boot, yeah. And they've been around Australia for a really long time. They can be spelt different ways. And what happened was a US company, well, an Australian registered the trademark and then sold it to Deckers, a US company that was making these boots overseas. And once they owned the trademark, they wrote to every Australian company, and many of them were quite small, who were making UGG boots and said, you're infringing our trademark because you have the word UGG boots in your title. You need to be calling them sheepskin boots, not UGG boots. And the McDougalls responded by saying the trademark should be struck off for non-use because the particular spelling hadn't been used for more than 3 years. And I've got a quote there for you from the Register of Trademarks. There's a lot more to the story, but this is enough for our purposes today. So the court said, the evidence overwhelmingly supports the proposition that the term, and you can see the different spelling of UGG boots there, are interchangeably used to describe a specific style of sheepskin boot and are the first and most natural way in which to describe these goods, which should innocently come to the minds of people making this particular style of sheepskin boot. And then he or she concluded that the term lacks any inherent capacity to distinguish the particular goods. So what they're saying is by using the term Ugg boot, you're not actually distinguishing your goods from anyone else who's also selling Ugg boots. Therefore, because the so-called trademark wasn't distinguishing goods, it couldn't be registered, or it should be struck off the register because it wasn't distinguishing goods. The Deckers, just to give you more context, the Deckers were not at all happy about the idea of not being able to call their boots Ugg boots, because that's what everybody would Google and that's what everyone in Australia called them. And if they weren't allowed to use the term, they were worried that nobody would know what they were actually selling. And if people just Googled Ugg boot, all they would get is the US brand and not them or any of the other small Australian businesses making them. Now, it was a good news story for the small company in Australia, not a good news story for another action against Deckers by Deckers in the US. If you want some constructive procrastination, you're welcome to borrow the DVD from the Chifley Library, or the Law Library, sorry. And there's a recent news article there for you if you want to follow up on it further. But as far as the law, the legal principle that you're taking from this is that if the word that's trying to be someone's trying to trademark is the first and most natural way that people would describe that good, then it can't be trademarked because it's not distinguishing that good from other competitors. And there's a recent case, Taronga Zoo versus Sydney Zoo. It ended up being settled out of court. Has anyone gone to Taronga Zoo in Sydney Harbour? Yes? So it's in the centre of the city, really, and it's overlooking the harbour. It's been there for many, many years. It's in Mosman. And there's a new zoo being built in Western Sydney, which is doesn't have any water views compared to Mosman. It's not near the centre of the city. I think it's an hour out of the centre of the city. And the new zoo, they want to call Sydney Zoo. They wanted to call Sydney Zoo. And Taronga, they were trying to register the trademark Sydney Zoo. Taronga Zoo, which is the original zoo, opposed the registration of the name Sydney Zoo under the Trademarks Act. They said it was too similar to their trademark, and they also said it was a breach of Section 42, which prohibits the registration of trademarks that are contrary to law. And they said the trademark that Sydney Zoo contravenes Section 18 of Australian consumer law, misleading and deceptive or likely to mislead or deceive. And so those were their grounds for objecting to it. And IP Australia originally found in favour for Sydney Zoo and let them register it. Taronga Zoo then appealed to the federal court and the parties settled. Do you know what it means if they settle? They negotiate and reach an agreement before the court makes a decision. It saves the parties a lot of money, but it's not great for us because we don't have a court decision to use as legal authority. And there's a video there, and there's some journal articles on that particular decision. Because the court didn't get to actually make a judgment, that's sort of the best I can offer you. The reason Taronga Zoo objected to Sydney Zoo, apart from the Section 18, was they said people are going to think Sydney Zoo is us. They're going to think Sydney Zoo is Taronga Zoo, and they will buy the tickets thinking they're coming to our zoo and then find out they have to go out. And we might have people turning up trying to validate the Sydney Zoo tickets at Taronga Zoo. And also the logo was really similar. So part of the negotiated agreement between the parties was to change the animals and some of the way the logo and the colouring of the logo to enable consumers to distinguish between the two zoos. The two Kylies, Kylie Minogue and Kylie Jenner, have also sort of come to blows over who is the Kylie that can be trademarked. And Kylie Minogue was successful in that particular case. If that's a story that you're interested in, didn't happen in Australia. I think it was a UK or US jurisdiction case. And then I just wanted to give a couple of international examples. And there's a really interesting article on the IP Australia website. IP Australia, Intellectual Property Australia, it's where the Trademarks Commissioner is, but also IP Australia is responsible for administering those 4 pieces of IP legislation that we've talked about in the lecture today. And there's a really great article there about some of the difficulties that Penfolds Australia and other Australian companies have had registering trademarks in China. And part of it, I think, was they must have had IP lawyers, but possibly they weren't Chinese-speaking lawyers. I'm not quite sure. But anyway, so what happened was, Penfolds is a wine company, and they registered Penfolds as a trademark in China, but they did not register the Chinese version of its name or the transliteration. And for those of you who speak or can read Chinese characters, the IP Australia website actually has the characters in that article, so you can look at the differences between what was registered and what should have been registered. And what happened was an enterprising Chinese businessman registered the Chinese versions of Penfolds, and the hotels started stocking his wine because they didn't want to breach the trademark law. Okay, and he had the trademark or the copyright to use the Chinese version of Chinese characters for Penfolds. In 2017, the Chinese People's Court cancelled the trademark registered by the businessman, arguing for non-use, that at the time that it had been registered, it was under Chinese IP law, which I don't understand, I don't know anything about, but I think at the time that he registered the trademark for the Chinese version of Penfolds, he hadn't been using the trademark. He only did it after registration. It's just, I think it's a good example showing some of the challenges for people working in different languages and trying to sell products in different countries. Okay, so what are your remedies for unregistered trademarks? So I said earlier, if someone hasn't registered their trademark, they can't get any support or joy, or probably remedy is a better word, under the Trademarks Act. Okay, but there still might be a way that you can find your client a remedy. You might be able to find them a remedy under the tort of passing off. Now, in an exam question, if somebody has registered their trademark, just talk about the Trademarks Act. Don't talk about the tort of passing off. Won't get you any extra marks. This is only relevant in the context of an unregistered trademark. So in order to get a remedy for an unregistered trademark, you must have the existence of some reputation or goodwill in the name, markup or get-up, packaging, what the product looks like, and there has to be deceptive conduct on the part of the defendant by the use of the same or deceptive similar name, and there has to be either actual damage or the threat of damage to the plaintiff's business reputation or goodwill as a result of the defendant's conduct. So that's a much more stringent test than under the Trademarks Act. So it'd still be better to register your trademark if you can. I think the recording might stop soon. Yes, we might. I'll just go through this case and then I'll stop so students who aren't here don't miss out. So Peter Bodum is the case authority that you'll use for that test on the previous slide. And this this case regarded coffee plungers. I have one of these at home, but I keep breaking the glass. Bodum made coffee plungers, and they argued that DKSH was advertising and selling the Euroline coffee plunger, but it looked just like the Bodum coffee plunger, and the labelling and the way it was presented looked very similar. And they said because they hadn't distinguished it from the Bodum coffee plunger, they were trying to pass off or trick people into thinking that the Euroline coffee plunger was in fact the Bodum coffee plunger. And the court found that that test set out there on slide 66 had been met, and therefore there had been a breach and damages could be proven, so damages were paid. All right, we might just stop there. So I'll start, so the lecture next week will start off with slide 68, and then the rest will be practice exam questions. Your tutors can assist you if you want assistance before the lecture next week. If you've been doing some practice questions, you can take them to your tutor in consultation and get some feedback from them for 2018-2017 exam papers. They can look at your answers and help you, will give you some feedback about whether you've been identifying the correct legal issues. I'll certainly be going through it on Friday as well, but if you want some feedback before then, meet with your tutors in consultation. All right, I'll see you all next week for the last lecture on the last day of the semester.